Boy, Jack Smith is having a heck of a time with Judge Eileen Cannon on the classified docs case.
Poor baby.
And maybe he is because he and his team, including the FBI, have not distinguished themselves in the decisions that have been made in pursuit of Trump on these classified documents-related charges. We're getting more information about these classified documents and sort of the agitprop associated with them after the Mar-a-Lago raid. Julie Kelly arguing that I'll just read her tweet. As I reported last month, the FBI brought colored classified cover sheets to the raid under the guise of using them to substitute classified documents found within Trump's boxes. Instead, FBI agents attached the scary-looking sheets to various files and took photos. In DOJ's opposition to Trump's special master lawsuit in 2022, Prosecutor Jay Bratt he's prosecutor. Jay Bratt attached infamous photo as a prop so the media would publish it and claim the papers were found with classified cover sheets. So, I mean, just the manipulation of what was actually found and then photographed and then released to the media, some of which turns out not to be true. In point of fact, this is disclosed in discovery in a court filing Wednesday evening. Attorneys for Trump criticized the photo and its inclusion in the brief. The government filed opposing Trump's request for a special master to review the retrieved documents. The government's response gratuitously included a photograph of allegedly classified materials pulled from a container and spread across the floor for dramatic effect, the filing said, which is correct. Then ABC News actually goes on to say, pay special attention to the cover pages. We now know were not originally attached to the documents. The photos, ABC News reporting, the photo shows numerous documents on the floor of Trump's personal office, including color-coded cover sheets bearing classification markings in big bold lettering.
The whole world saw that.
An examination of these cover sheets alone tells you a lot, said Douglas London, a 34-year CIA veteran. As the most important intelligence customer, it should be no surprise that the president receives the most sensitive information, and that's reflected in these documents. So the cover pages were added post hoc by the FBI. Is that a big deal? It would seem to be. Why is the FBI in the business of staging for the purposes of DC press corps reporting, as opposed to investigating for the purposes of law enforcement? Are the two mutually exclusive? For more on this and more legal matters, we're pleased to be joined by Andy McCarthy, former Chief Assistant U.S. Attorney in Manhattan, contributing editor to National Review, and author of Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thanks for being with us. Appreciate it.
Morning. Good to be with you.
So your view on this chicanery in the documents case?
Well, it depends on whether it's chicanery or not. I agree completely with the business about staging a photograph for public consumption. That should not have been done. And, look, it's not going to be enough to get the evidence suppressed or to throw the case out, but, somebody ought to be walking the plank over that.
Mm-hmm.
At the same time, let's say, let's put the media circus part of this aside and say you're an agent who's doing a classified documents case, right? And I'm not saying this is what happened. I'm just saying hypothetically why you could see why this would not be all that problematic. You go into a location that you're allowed to search because you have a warrant, and you find classified documents on the floor or in the premises or whatever. So what I would want as the prosecutor, I don't know at that point in time what the judge is going to allow ultimately in the trial in terms of what classified information comes into the case or not. So what I want the agents to do is take a picture of exactly what it looked like when you went in there with no adornment, no anything else. And so we could preserve exactly what it looked like. And you could testify that yes, when I walked in the room, this is what I found, and then take these cover sheets and cover the documents as categorically. In other words, if you have like a top secret document and you have a top secret cover sheet, put the cover sheet over the document and then take another photo. That way you haven't manipulated the crime scene because you preserved what it originally looked like. But at the same time, if later on the judge says this or that classified information can't come into the case, you've covered it so that you've preserved the secret, but the jury could still see what the room looked like when you came into it, which is the whole reason that you take pictures. If that's why they did it, Dan, I wouldn't have a problem with it. If they did it to stage a photo to prejudice Trump in the press, and that was the only reason for doing it, then I say people ought to get fired over that.
I wanted to get your take on another argument that's being advanced by the Trump defense team, that Jack Smith's appointment is unconstitutional because Merrick Garland had no statutory authority to unilaterally empower him to be a special prosecutor.
Yeah, I wrote a long piece about this over the weekend at National Review. I think there's a lot to that motion. I mean, basically, it's a little bit confusing for two reasons. The appointments clause is not, it's the Constitution. It's not exactly the clearest thing especially for those of us nowadays reading it, because it's articulated in a style of the late 18th century rather than now. It's not. I'm not saying it's inscrutable. I'm just saying it's not the easiest read, so you have to break it down a little bit. And then the other thing that's confusing is this distinction between who's a principal officer, like the Attorney General is a principal officer. All principal officers, most of whose offices are created by the Constitution itself, have to be nominated by the President and confirmed by the Senate. Then there's another category of what's called inferior officers. They have to be created by Congress, which is why, in a statute, which is why Jack Smith can't be one. His position is created by a Justice Department regulation. But it's a little confusing who's a principal and who's an inferior officer, because Congress gets to say how you confirm inferior officers, how you qualify them. And sometimes Congress writes into the statute that the inferior officer also has to be nominated by the President and confirmed by the Senate. So, for example, are U.S. attorneys, district U.S. attorneys, are they inferior or principal officers? There's a good argument for both, and you can't tell just because they're, the fact that they're nominated by the President and confirmed by the Senate doesn't necessarily clinch it. But the point is, you can have a long argument about all that stuff, but if you look narrowly at Smith, he's not nominated by the President, he's not confirmed by the Senate, and his position wasn't created by a statute. So I don't see how he can be an officer of the United States, which I think he has to be to wield prosecutorial authority without supervision. And what he's saying is that he's an inferior officer, which I don't think he can be. And the other thing he's saying, which I think is the big issue here, is his appointment is fine because he's closely supervised by the Attorney General. And my point is, the whole appointment of Smith was a political head fake so that Merrick Garland and Biden could claim that they had nothing to do with the prosecution of Trump.
Right.
So how can he now say that it's okay because Merrick Garland's been closely supervising me, since Merrick Garland's been telling the country for 2 years that he lets this guy operate independently with no supervision?
Good argument. Judge Eileen Cannon, she's getting sort of the Sam Alito, Clarence Thomas treatment now. She's over her skis. She's in the tank for Trump, so on and so forth. What's your assessment of how she has managed this case thus far?
Yeah, I think if you have idiots who are like partisan hacks who are covering the case and writing about her, that's the kind of nonsense that I almost said the wrong word there, Dan.
Yeah, that's all right. You caught yourself.
That's the kind of stuff that you hear, right? But if you watch this case closely, first of all, she's ruled against Trump plenty of times. I think that the thing is, the Democrats and their apologists, especially for these prosecutions, are used to having proceedings in Manhattan and Washington where basically the judge does pretty much what the prosecutor tells the judge to do.
Mm-hmm.
And down in Florida, what we're seeing is a fair trial, and what that looks like, which means, sometimes you win and sometimes you don't win, and a lot of it depends on like the strength of your position, not who you happen to be prosecuting. And I think if you're going to blame Cannon for the fact that this case seems to be mired in pretrial proceedings, you're blaming the wrong person. This case was overcharged by Jack Smith. A competent prosecutor could have written a tight obstruction indictment with about 8 charges against Trump, so there would have been plenty of criminal exposure. You wouldn't have had to get into all of the classified information litigation that he's had to get into, because it wouldn't matter what the content of the documents was. The only thing would matter is, did they have classified markings on it? Because that's what the subpoena that he got that Trump got from the grand jury called for. So the reason this case is mired, and the reason it hasn't been able to get to trial, and the reason that there's no trial date on the horizon, is not because of Judge Cannon. Everybody who's ever done one of these cases knows a classified information case of this type, where he larded 32 classified information counts into the indictment, is very, very hard to get to trial, even if it's the only thing you've got going and you're trying really hard. But he could have tried this, he could have indicted this as an obstruction case, and he could have gotten to trial quickly if that was what his objective was.
Well, I wanted to move on. Last Friday, the Supreme Court ruled that a jury must be unanimous to convict someone of a crime. Does that open the door for Trump's hush money case to be potentially declared a mistrial?
Yeah, I think that door was already open, Amy, but but what the court said reiterated an important principle. Now, I personally think that the count that Trump was convicted on, the theory of the case there was that he falsified his business records to cover up a conspiracy, and the conspiracy was conspiracy to influence an election by unlawful means. And what he said was that the jury didn't have to be unanimous on the unlawful means, because that was just the means of the conspiracy, not the objective. And that's just a ridiculous theory under the criminal law. Very simply, a conspiracy is an agreement by 2 or more people to violate a law, to violate a criminal law. There is no such thing in the criminal law as conspiracy to influence an election, because influencing an election is what campaigns do. It's totally lawful. What makes it a criminal conspiracy is the unlawful means. And therefore, the jury has to be unanimous on what the unlawful means are. Otherwise, there's no conspiracy. So I'm glad the Supreme Court ruled what they ruled, because it just makes the point clearer. But the reason that this was a travesty, one of the 27,000 reasons this was a catastrophe and a travesty, is that the judge instructed the jury that they didn't have to be unanimous about the objective of a conspiracy. And that's ridiculous, because if they're not unanimous on the objective, there's no conspiracy.
Yeah, but again, that's in a place where they have eschewed the standard of having a fair trial. So you have to keep that in mind, too. That's the problem in Florida. You just said it, that there's a fair trial going on in Florida, and that is what Democrats find obnoxious. I mean, I think that's the most telling statement of all, particularly because it's so accurate. I wanted to get your take on something else. The appeal that Hunter Biden's lawyers have made for a new trial on basically a legal technicality, saying that their appeal to get a full panel of appellate judges to hear a couple of their other substantive appeals didn't happen prior to trial, and so the Judge Noriega didn't have jurisdiction because of the pending rules in the appeals in the appeal process.
Yeah, I think that's pretty frivolous, but
Yeah.
It wouldn't be the most frivolous argument they've made. Look, all defendants who think they have a meritorious legal claim that they don't win in the district court, the trial court, they all want to get to appeal before the trial, right? Because they think the legal thing is what blows up the case. But as we've seen with Trump's immunity litigation, there's only a few issues that federal criminal law allows you to appeal prior to trial. And they're all issues that go to the question of whether you should be brought to trial in the first place. So the only issues that really covers are things like immunity or double jeopardy, because then the constitutional violation is putting you on trial, not just convicting you, but putting you on trial. The theory in federal law is everything else can wait till the end. So whether a judge is right or wrong on legal issues, and I think Hunter has some pretty profound, I don't think he'll win in the end, but I think he's got some very colorable Second Amendment claims to make on appeal.
Right.
But he lost them in the district court. And what happens when you lose those is you appeal them. And maybe, when he gets up to the circuit, in several months, maybe they'll look at it differently than Judge Noriega did. But there was no problem with her going forward with the trial. And I don't think Hunter's going to be placed in prison pending appeal. So he'll be at liberty. He'll get to litigate his appeal. And if he wins in the circuit, God bless him. It'll get thrown out.
And Trump, when he's sentenced on July 11th, he'll get prison time. He'll be free pending appeal, bonded out pending appeal. Then he'll win. Then he'll serve the first 90 or 120 days of his administration. He'll govern from a prison in he'll govern from Rikers Island. And so we're gonna, right? I mean, that's how I see it playing out, or maybe that's just my dream Law and Order episode. But what do you think?
Well, look, I grew up in the Bronx in the 60s and 70s when a lot of the mob guys were in jail from time to time. So it's not true that important decisions about governance don't happen in prison.
Exactly.
But I actually think Trump's going to get bail pending appeal. I actually think that gives Merchan an even more powerful incentive to give him a prison sentence, because he knows he's not really going to end up in prison.
Well, right. The other thing on that, though, too,
for show.
Just on the prison sentence, right? Because it's all for show. You have to impose prison time and serious prison time, because if you didn't, then what was this all for? If you give him probation, right?
Not only that, Dan, the grand jury indicted a puny falsification of business records case. But Alvin Bragg put out a statement of facts the day of the indictment, and they tried the case on the theory that Trump stole the 2016 election. Now, if you told the jury that you stole the most important, awesome office in the world, what do you then say after you convict him of that? I think that's worth 29 hours of probation. I don't think so.
Andy McCarthy, former Chief Assistant U.S. Attorney in Manhattan, contributing editor at National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thanks as always.
Thanks, guys. Have a great day.
You too, and he joined us on our turnkey.pro answer line.
It's like a hot, steaming cup of information to start your day. It's Chicago's Morning Answer on AM 560. The Answer.
Conveyors keep your products moving, but when they break down, it can cost your company time and money.